Mandatory arbitration refers to terms within all sorts of contract clauses and provisions. A mandatory arbitration clause states that potential conflicts between parties cannot be litigated in court. Instead, legal problems can get resolved through the private process of arbitration. This situation often takes place between employers and employees. Or, a company can insert a mandatory arbitration clause in terms for any transaction such as buying a car. Both terms have the exact same definition. Through mandatory arbitration, disputing parties will attend hearings conducted by neutral arbitrators. The arbitrators will analyze evidence and listen to arguments. This way, a final outcome can take place ASAP. Once hearings conclude, the arbitrators can enforce that the losing party pays the winning party money. This payment process is known as the arbitration award. The terms of mandatory arbitration are always binding. This means that, unless under rare circumstances, each party decision cannot be appealed. In fact, this leads to the main difference between binding and non-binding arbitration. If arbitration is non-binding, a party can reject an arbiter's decision and award. That is why almost all arbitration clauses have binding status. Through binding arbitration, parties have no choice but to accept the arbitrator's decision. This is an example on why it is crucial for you to understand the exact wording of each contract that you sign. Otherwise, a party can pursue legal action against you through mandatory arbitration. These days, the majority of consumer and business contracts feature mandatory arbitration clauses. The popularity of mandatory arbitration in the US continues to rise every year. Why? Because individuals and businesses alike are realizing the benefits of arbitration. One key benefit has to do with time. Standard court cases have a reputation for lasting many months or even years. That is not the case with mandatory arbitration proceedings. The majority of arbitration hearings can last 1 to 5 business days. Saving money is another benefit of mandatory arbitration. Court litigation is, on average, much more expensive than arbitrating a dispute. Since the arbitral process is brief, individuals and companies can save thousands of dollars. Plus, disputing parties can even have say in who the arbitrators are. The parties can appoint arbitrators with skills and experience that applies to each dispute. That is never the case when working with a courtroom judge. Mandatory arbitration is legal across the United States. It is best to research your own state's unique laws about arbitration. This way, you can draft an error-free mandatory arbitration clause. Here's an example of state law that affects arbitration. In 2020, the California legislature passed a mandate stating employers cannot require employees to sign arbitration agreements. This refers to agreements mentioning discrimination, harassment, and wage claim. Plus, the California employer cannot retaliate if an employee does not sign an agreement. Feel free to let our association know if you need help interpreting your state's mandatory arbitration laws. Then, our team can help you or your business draft an agreement that protects your assets. In fact, we encourage you to call our association with any questions about arbitration. You can reach our ADR experts at 844-554-0444. You can also learn more about mandatory arbitration on our official website, arbitrationagreements.org. The site even features sample mandatory arbitration clauses that you can download. We look forward to helping you and your organization succeed in all aspects of arbitration.